All right. So where's the proof? 2023 CR 0527, State of Texas versus Sebastian Johnny Castillo. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense,
Garrett Chirac for the defendant.
are you Sebastian Castillo?
Yes, Your Honor.
All right, you entered a plea on March 30th to count 1, paragraph B, no contest. According to the plea bargaining agreement, punishment is to be assessed at 5 years in the prison. There's an affirmative finding of deadly weapon. State is not making any recommendations to your application. There's an affirmative finding of family violence, and then there's to be no contact with several parties. Did you have a chance to review the PSI report, counsel?
Yes, I did, Your Honor.
Right off the bat, the judge is setting the tone. This isn't just a casual hearing. The PSI, or pre-sentence investigation report, is like a background check on steroids. It tells the court who this defendant really is beyond the charges. No objections from either side? That's a silent signal. Both prosecution and defense might already know how this one's going to go.
State,
Yes.
any objections to the PSI report?
No objection, Your Honor.
All right, the state is silent. So any witnesses, defense?
I don't have any witnesses. I just have my defendant.
All right, do you wish to call him?
Yes, ma'am.
All right, can you raise your right hand for me? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
You can lower your hand, state your name for the record.
Sebastian Johnny Castillo.
Defense,
Mr. Castillo, do you want a statement you want to make to the court?
I just like to say I'm sorry to my mom, my brothers and sisters.
How old were you when this happened?
I was 17.
Okay, were there some family dynamics going on in this situation with your step parents and your siblings?
Yes, sir.
What was exactly going on? You recall?
I was being beaten and I got kicked out.
I'm sorry, you were being what?
Beaten.
Now here's where things take a serious turn. Sebastian says he was being beaten, but no reports, no documentation, no school record. In court, that's a red flag. Judges deal in evidence, not emotion. But think about it, if he really was 17 and terrified, would you have reported it? The tension here isn't just legal, it's human.
No further questions.
All right, who are you saying was beating you?
My stepfather.
And where's the proof of this?
Just his, were any police reports made on this?
No.
Well, did he tell the school?
You tell the school you were getting beaten?
I was kicked out and they went to withdraw me at the school and the cop was there. And whenever they were taking me back home, they kicked me out and I was out for 3 days.
No, my question still has not been answered. So he's saying that his stepfather was beating him at the home.
Mhm.
So did he ever report it to the school? That's either yes or no. All right. So where's the proof? Because what I have is I have him going to a home. I have him where they say that he threatened to shoot up the school. That's why the mother called. And then I have him going back to the home and they're saying that he pointed a gun on them.
Judge, I'm saying here that I think what led to this was they, for some reason, the step parents wanted him out of the situation. He denies that he ever made a threat to shoot up the school. He says that was a false threat. I think they just wanted him out of the house. When this happened, you were actually living with your grandparents. Is that correct?
Yes, sir.
And if you get probation, that's who you would live with?
Yes, sir.
And when this happened, you were what, 17?
Yes, sir.
And do you do any alcohol or drugs?
No, sir.
Now, according to the police report, it says S1 and S2. S1 grabbed a handsaw and you're S1. It says S1 grabbed a handsaw and attempted to saw through the lock to the gun safe. S1 then found a grinder and cut through the lock. S1 and S2 grabbed multiple guns from the safe and gathered them together. The cousins who went with S1 were waiting outside the laundry room with guns in their hands. S1 and S2 also gathered other listed items as well. Victim 3, 4, and 5 were all sitting in the living room sofa. Victim 3 said that S1 and S2 went into the living room and kitchen and had some of the guns pointing at them. S1 told victim 3 to shut the F up or he will shoot them. S1 and S2, along with S1's cousins, left the location with all the items he took. Once they left the location, V3, which is victim, locked the doors. Victim 2 arrived shortly after and called out to victim 3 to open the door. That was when victim 3 told victim 2 what happened. Victim 2 then called victim 1, who called the police to make a report. So, anybody want to address that? Because victim 3 is a juvenile. Victim 4 is a juvenile. Victim 5 is a juvenile. So,
You're shaking your head.
No, no.
are you saying you didn't take these items?
No, ma'am.
I mean, it's what you pled to. All right, is there anything else?
Nothing further, Your Honor.
All right, I'll hear argument.
Judge, at the time of the incident, the defendant was 17 years old. It sounds like it was a family dispute matter. Allegations are of guns being pointed, no shots were fired. It's evident that.
And there it is, 5 years behind bars. The judge acknowledges his age, but the decision's firm. Notice the phrase, affirmative finding of deadly weapon, that's key. It legally marks him as someone who used or displayed a weapon in the crime, which means no early parole. It's a tough call between mercy and accountability. What do you think? Fair sentence or too harsh for a 17-year-old?
The parents and stepmother and stepfather do not want him in the location. That's not a problem. He's young. He's got his whole life ahead of him. I think he realizes he made a mistake in that situation. Maybe his anger being removed from the family caused him to kind of have a moment of basically being stupid.
And see, I can understand his position if there were people in the home where this was not their stepfather as well. So this is what the court is going to do. Court is going to find you guilty, sentence you to 5 years in prison, give you credit for any time served. There's an affirmative finding of deadly weapon, an affirmative finding of family violence. There's to be no contact with victim. With regards to the restitution amount, the court does not, they're asking for $45,000 in restitution. The court has nothing before it to suggest that restitution should be $45,000, and no information on restitution has been presented to the court, so the court is not ordering restitution. I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. You won't probably want to go around. Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because this is an affirmative finding of family violence, and also because this is a conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you. I know we're off the record. I know you're young, and 5 years seems like a lot of time.
Yes.
Time does go by quickly, but you need to start bettering yourself. If there is some type of mental health issue going on, or some other issue that you have, drug issue, or some type of trauma that you've suffered, you can ask for help and they will give it to you. Do you understand?
Yes, Your Honor.
All right, good luck to you. 5795, State of Texas versus John Leo Closa. Can I have parties announced for the record for the state?
Travis Banks of the state of Texas.
Defense?
Ideli Silver for the defense.
Are you John Leo Closa?
Yes, ma'am, I am.
Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney?
Yes,
Did you understand it?
Yes, I did, ma'am.
Are you the same John Leo Closa who was placed on deferred adjudication in 2021 CR 5795 for the offense of assault of a pregnant person on August 31st, 2021 for a term of 5 years? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 7, on or about the 30th day of April 2023 in Wilson County, Texas. The defendant, John Leo Closa, departed Bear County without the written permission of the court and or the supervision officer in violation of condition number 7.
How do you plead to that? True or not true?
True, ma'am. Say will waive and abandon the other allegations.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 7, the court could find it true, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition number 7?
Yes.
Court will find violation of condition number 7 true. Is there an agreement?
Yes, Your Honor, the agreement, should the court follow it, is to deny the motion and to alter and amend the conditions to add hostility and aggression management course and the family violence impact panel. And those, with those additional conditions, that is.
All right, why are we needing hostility management and anger course and family violence impact panel when he was supposed to be doing the BIPP course?
He has finished the BIPP course. It was finished last year. Yes, and then there's a new allegation of a new number 1 in Wilson County. It is still pending.
So why should I continue him on probation? I don't understand. He leaves the county without permission. I'm not even going to consider the fact that there is a pending case in Wilson County because you all didn't go on that. But I do have the state and you all agreeing to hostility management course and the family violence impact panel live. So I'm trying to figure out, why shouldn't I not just send him to prison?
Well, he has completed many of the things that he had to complete, and he's only 2 years in, so he has 3 more years to go on his probation.
Why is he leaving the county without permission?
It was 25 minutes from his home. I mean, technically it still is out of the county, but it's 25 minutes from his home for a family function with his family.
State?
You're right. I think in the hostility and aggression management course, they do teach some different skills than you learn in the matters intervention course. And I think that maybe with these new skills, they could serve the defendant well and that he could complete the rest of his probation successfully.
All right, this is what the court will do. Is there anything you wish to say, sir?
Ma'am, I apologize for my actions and I won't mess up again. If you please can give me this opportunity to prove to you that I can do better, I will, ma'am.
All right, this is what the court will do. Court will deny the motion, alternate amend conditions to include hostility management course, family violence impact course live panel, and 10 days in the Bear County Jail as a condition. All right, so you're going to go into custody today, serve your 10 days in the Bear County Jail. And what you need to remember is you have to follow the rules of the court. Do you understand?
Yeah.
All right, so immediately upon your release, you need to get in touch with your probation officer, and you need to remember you're not allowed to leave the county. You understand?
Yes, ma'am, I do.
And you need to remember that the rules of this court are the rules of this court, because this contract is not between your attorney and the state. This contract is with the court. Do you understand?
Yes, ma'am.
All right, good luck to you. 20 CR 10019, State of Texas versus Eric John Orta. Can I have parties announced for the record for the state?
Ruben Herrera for the state.
Eddie Garcia for Mr. Orta, Your Honor.
And are you Mr. Orta?
Yes, ma'am.
Showing you a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Eric John Orta who was placed on deferred adjudication in 2020 CR 10019 for the offense of assault of a pregnant person on April 6, 2021 for a term of 2 years and extended for a total of 2 years? Is that you?
Yes, Your Honor.
State.
Your Honor, the state will be proceeding on a violation of condition number 15G in that on or about the 14th day of June 2023 in Bexar County, Texas. The defendant, Eric John Orta, did then and there fail to register for or attend battering intervention prevention program with an approved agency in violation of condition number 15G.
How do you plead to that? True or not true?
Sure.
State.
The state would waive and abandon all other violations.
Any objections?
None, Your Honor.
All right. Did you understand by pleading true to violation of 15G, court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of 15G? And do you understand that any agreement that you have come to with the state, the court does not have to follow that agreement? Do you understand that?
Yes, Your Honor.
And knowing that, you still wish to plead true to 15G?
Yes, Your Honor.
Court will find 15G true. What is the recommendation from parties?
Your Honor, the proposed recommendation would be for the court to enter an adjudication of guilt and sentence the defendant to 2 years in the prison.
All right, is that the agreement?
Yes, it is, Your Honor.
Why should I sentence him to 2 years?
Your Honor, the agreement would take into consideration the two new number ones that were alleged. Counsel did tender an affidavit of non-prosecution from the complaining witness today. The complaining witness in the assault family second is the same complaining witness on this on the underlying charge in this MTR, Your Honor. And she was uncooperative at the time that the underlying case was resolved as well.
And more specifically, Judge, she said that she lied about it. I had an affidavit this morning that she sent to my client's mother, handed it to Mr. Herrera, and she reviewed it. So.
What has he done on probation?
Well, he's completed several, well, I let probation speak about.
Okay.
Your Honor, it appears he was in drug court and he finished that. Other than that, I don't have any other completion. There were several failure to submit on his drug tests. He did not complete the VIP course.
He says he completed lifetime recovery. I don't know if you have any.
And the outpatient program.
Mhm. See, I don't know. Did felony drug court accept him?
Let me double check.
Because I do see where he was sent to lifetime recovery. Did felony drug court accept you?
Yes, initially they did, yes, Your Honor.
All right, do you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand. You're going to need to speak up. State your name for the record.
Eric John Orta.
All right, so what do you mean that felony drug court initially accepted you? What happened?
They had accepted me, Your Honor, and I didn't comply with one of the rules of not, I believe, coming in and continuing the program with them. At that moment, they had made me MTR. I came and I did the 90 days of lifetime recovery. And then once I came out of lifetime recovery, I finished the after program. I followed all the rules of that. I stayed sober. I'm still sober to this day, ma'am.
Why didn't you do the BIPP course?
Ma'am, honestly, I just didn't get to it. I just wasn't thinking about it. And that is a horrible decision on my part. And I don't have an answer to give you for that, ma'am, as far as any excuse.
Your Honor, if I may.
Yes.
Yes, all right. Due to non-compliance, he was discharged from the drug court program. He did finish the 90 days in lifetime recovery.
Okay. Is there anything else that anyone else would like to say?
Nothing from this.
You can just ask the court to follow the agreement, Your Honor.
All right. The court is going to grant the motion. The court is going to find you guilty. Not grant you community supervision. There's an affirmative finding of family violence. The court will sentence you to 4 years in the prison. Give you credit for any time served. There's to be no contact with Jessica NAVA, NAVA, and states you're dismissing the assault family second and the criminal mischief charges.
Correct, Your Honor.
All right, the court will take in consideration Night Mag number 799937, which is the assault family second, and County Court Cause number 710566, which is the criminal mischief case.
Judge, would you reconsider, based on the violation that he pled to, it seems like the punishment of 2 years would be more appropriate than the 4 years that we would wanting to sentence him to. That's the reason that we entered into this agreement, is based on this violation.
All right, the court is going to keep the sentence at 4 years. The court will give him credit for any time served, credit for any inpatient treatment. I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, you have a limited right to appeal. That right to appeal is as it relates in the allegations in the motion, counsel. That's that. The limited right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand?
Yes, Your Honor.
All right, good luck to you.